Rifkin, I think this was a very good exchange between you and Senator Blumenthal, and I would note prosecutorial discretion is a long-standing doctrine, and so it would certainly be a acceptable decision of prosecutorial discretion, for example, for the department to determine it would prioritize deportations or prioritize prosecutions for violent criminals, such as the individual, the case that Mr. Kobach pointed out. That would be a traditional use of prosecutorial discretion. We're going to focus first on the most dangerous criminals. But there is a qualitative difference here. This is not simply saying where are we going to focus our prosecution resources first. This is affirmatively printing authorizations to violate federal statute. And indeed, Mr. Rifkin, you have a lot of years' experience in the Department of Justice. Are you familiar with any example, as Senator Blumenthal asked you, where not only did a U.S. attorney decline to prosecute a bank robber, but the U.S. attorney cranked up the printing press and printed up a authorization to rob banks and handed it to the person and said, you are hereby authorized to each day forward violate federal law. And over the course of 365 days, you may rob 365 banks, because the work authorization each and every day purports to authorize an alien here illegally to violate federal statute. Are you aware of any other context in which the department has purported to issue a license to violate federal law?
No, I'm not, Senator Cruz. In fact, thinking about this issue as to how else it could have been done, I pondered briefly the question of pardon power, because pardon power is one of those absolute powers, Brooks, no limitations, no judicially reviewable. But in pardon power, it can only be exercised for past violation. No president can pardon somebody for things you've done in the past and then say you can do a couple more in the future. No, this is a compelling example, aside from not case by case, why this is not prosecutorial discretion. My testimony, I use the example of IRS. Another favorite agency, if IRS decides that you violated tax law, at best they'll let you go. They may waive the penalties, but IRS is not going to send you a financial boon, even of a small magnitude, because they decided that you deserve it. So this gives a bad name to prosecutorial discretion.
Well, and let me go back, Professor Family. You and I had an exchange where you said that the statutes did not, if I understood you correctly, prohibit employment of those who are here illegally. If you look at Section 274A of the Immigration and Nationality Act, it provides, it is unlawful for a person or other entity to hire or to recruit or refer for a fee for employment in the United States an alien, knowing the alien is an unauthorized alien. Now, that is an explicit prohibition, and every one of those work authorizations that is purported to be handed out under executive amnesty is an authorization that purports to give that individual the authority to violate that statute, or their employer the authority to violate that statute.
Yes, Senator, but there's also another statutory section where Congress has, in its defining who is unauthorized to work, and has said that you're not authorized to work unless you've been authorized to work by this act, meaning the Immigration and Nationality Act, or the Attorney General, which that's under the old language when the Immigration and Naturalization Service used to be part of the Department of Justice. So that now means Secretary of Homeland Security. So Congress has given the Secretary of Homeland Security, has delegated authority to make decisions about who is authorized to work. And so the Department of Homeland Security has taken that delegation and then through a regulation has said that people who get deferred action, and this regulation predates DACA and DAPA, has said that people who get deferred action are eligible to apply for work authorization.
Well, you're referring to Section 1324A, H3.
Mm-hmm.
But at the same time, so your argument, in order to be correct, is that by using the words "or by the Attorney General," that Congress has, in effect, given the Attorney General the authority to allow any person on the face of the planet the ability to work in this country. Now, using ordinary canons of statutory construction, if that were the case, the entire rest of this statute is superfluous. It could have been written as a one-sentence statute. The Attorney General can let in anyone they want. or keep out anyone they want. And I cannot imagine, and I would point out the alternative interpretation that any court would follow is Congress has periodically authorized the Attorney General to grant specific exemptions. For example, Congress has authorized the Attorney General to provide for work for battered spouses, as well as certain nationals of Cuba, of Haiti, of Nicaragua. So in that instance, the rational interpretation consistent with the canons of statutory interpretation is that the phrase "or by the Attorney General" refers to the specific categories where Congress has given the Attorney General or the Secretary of DHS the authority to make those determinations.
Well, I mean, I guess we just disagree on the interpretation of the statute, because to me that would make the language "or by the Attorney General" superfluous. I mean, why would we need that language if work authorization was only permitted by how Congress had said it was permitted under the Act?
So I want to make sure I understand your interpretation correctly then. You believe that that phrase "or by the Attorney General" gives today the Secretary of Homeland Security the authority to allow any one of the 7 billion people on the face of the planet the authority to work in this country?
No, because work authorization is a wholly separate issue from who will be allowed to enter the United States.
No, but you're saying that the Attorney General, anyone the Attorney General chooses, can be granted a work authorization. Could the Attorney General issue a work authorization? Every resident of the nation of China is hereby authorized to work in the United States. Would that be consistent with federal law?
Well, I think I disagree with your premise, because to me, who is allowed to enter or be legally admitted to the United States is a different question than who would have work authorization.
You haven't suggested any limitation that the Attorney General can only issue work authorizations to people in the United States. You have claimed the words "or by the Attorney General" give the Attorney General unlimited discretion to choose anyone to grant a work authorization. Is there anything you're pointing to in the statute that says they have to be physically present here?
I think my interpretation of the statute is that "or by the Attorney General" language means that Congress has delegated to the Department of Homeland Security the authority to make decisions about who is eligible for work authorization, and the Department of Homeland Security has done that through a regulation. And one of many categories of individuals who are eligible for work authorization are those who have been issued deferred action.
Would it be consistent with the theory you are putting forth for the Department of Homeland Security to grant work authorizations to every resident of the nation of China?
No, because again, I disagree with the underlying premise of your question.
Which premise is that?
Well, because I think that assumes that every citizen of China would be legally admitted into the United States.
But there's nothing in what you laid out that says legally admitted to the United States.
Well, but I think we need...
And indeed, Professor Family, if your qualification is that the Attorney General or the Secretary of DHS can only grant work authorizations to those legally admitted in the United States, then you have just admitted that the DAPA program is directly contrary to that statute.
No. I was just
we're not legally admitted.
Senator, respectfully speaking, I was just referring to your hypothetical about those.
So help me understand the legal difference you are positing between 4.5 million people here illegally and 1.2 billion people currently residing in another nation. What is the line? Because you're claiming unlimited discretion for the Attorney General, and I want to understand what is the legal line?
Well, again, I go back to my position that I think under the language of the statute, it gives the Secretary of Homeland Security discretion to decide who is eligible for work authorization. Of course, those decisions have to be rational. And I think if you look at the regulation where the Secretary of Homeland Security has made those decisions, they've made some, careful decisions about who's eligible for work authorization and who isn't.
Mr. Chairman, can I add 2 points on this very topic? I think Ms. Family's analysis of this is missing. It's being done in a vacuum and missing several federal statutes. The DHS Secretary doesn't have authority to give employment authorization to anyone. It has to be employment authorization to a person who is admissible to the United States, and it can't be contrary to another federal statute. Well, there are 2 federal statutes I can think of just off the top of my head that this is contrary to. One is 8 U.S.C. 1225, which is in my testimony, which says that these aliens must be detained for a removal proceeding Clearly, that is contrary to that statute, and the only court, the two courts that have specifically reviewed that have said it is. The second one, I don't have the statutory site memorized, but it's the unlawful presence 10-year bar statute. Most of these DAPA individuals, by being illegally in the United States the requisite amount of time, will have accumulated enough unlawful presence that there is a 10-year bar to them getting a visa to come into the United States and work. So there's two statutory barriers to the Secretary of Homeland Security doing what Ms. Family suggests he could do or she could do.
Professor Family, let me go back, because when one is positing a novel legal theory, the limits are highly relevant. So both the Obama administration and your testimony today have argued that prosecutorial discretion allows the president to refuse to prosecute and to grant work authorizations to some 4.5 million people here illegally. Can you give me any principled line that would prevent that discretion from applying to all 12 million people currently here illegally?
Well, I think that prosecutorial discretion is always guided by statutory concerns. It's always guided by rationality, right? It has to be rational. And I think, we're certainly nowhere near this situation.
You wouldn't say it's irrational for the president to grant deferred status to the 12 million, would you?
Well, I think I would need to know more about the administration's reasons why it was doing that.
If I can just add for 30 seconds, unfortunately for Plus Family, if it's truly prosecutorial discretion, rationality is irrelevant. Maybe as a political accountability matter, but as a legal matter, it's irrelevant because it's not subject to judicial review. So then we do have boundless prosecutorial discretion that cannot be either changed by Article 1 or by Article 3, and then the answer is trust me. And if people don't like it, they may not elect me, and if I'm not standing for election, then it's irrelevant. It cannot possibly mean that.
Well, Professor Family, let me also understand the extent of prosecutorial discretion, because not only under the Obama administration's terms would it apply to immigration law, would it allow the president to grant amnesty to all 12 million people here illegally, or for that matter, would it allow the president to prospectively grant amnesty to any person on the face of the planet who came illegally to this country going forward. But would it also, in your view, let's imagine we have a subsequent president who chooses to exercise prosecutorial discretion with regard to the tax laws, and he or she instructs the Secretary of Treasury, using prosecutorial discretion, you shall no longer collect taxes in excess of 25%. Now, I'll tell you, I happen to think that's a terrific policy as a matter of economic policy. But I also believe in rule of law, and I don't believe the president can unilaterally decree that. Is there any reason, under your theory of prosecutorial discretion, or rather under the Obama administration's theory of prosecutorial discretion, that a subsequent president could not simply decline to enforce the tax laws in excess of 25%?
Well, I think one of the things we would need to think about is what are the congressional policies underlying the statute that delegates the authority in the first place. So, thankfully, I'm not a tax law expert. Immigration law is complicated enough. So, I don't know enough about the tax statutes, but in terms of immigration law, the priorities are rational here. They're consistent with congressional policies that are underlying the statute. And, we need to keep in mind that what the Obama administration is doing is, they're not granting legal status. They're not giving out green cards. They are saying you are of low priority for us. It's a revocable thing. They could decide tomorrow, to actually deport the person. It doesn't provide the same security as a lawful immigration status.
Well, let me try to see if there are any limits to this theory. Earlier at this hearing, Senator Lee was here. Imagine in 2017 we have President Lee. Would President Lee have the authority under prosecutorial discretion to announce that the Lee administration will not enforce any federal environmental laws or any federal labor laws against any citizens of the state of Utah? Would that be consistent with prosecutorial discretion?
Well, in my mind, that would fail the rationality test.
Oh, no, he has a very good reason that he thinks the environmental laws and labor laws are hurting the citizens of Utah.
But not the citizens of any other state?
Okay, fine. I'll give you a second scenario. He announces we will no longer enforce the environmental laws or labor laws against any citizen of the United States. They're hurting everybody. Would that be permissible?
But that's not the situation that we have here. I mean, the Department of Homeland
I understand
Security
it's a
is still-
hypothetical. My question, and as you well know, having been a litigator, courts will frequently ask hypotheticals to determine the extent of a legal theory you're proffering. You're suggesting that the administration can choose to engage in prosecutorial discretion and not enforce particular laws. I'm asking, is there any limit to it? Could a President Lee say the federal environmental laws are hereby suspended in the United States of America?
No, I don't think that would be permissible, but I don't think that's what we're talking about today.
So why wouldn't it? Help me understand the principled legal distinction between that and what the president has done here.
Because here, the president is merely setting enforcement priorities as he's been directed to do by the Immigration and Nationality Act.
Well, then let me tweak the hypothetical. Suppose a President Lee says, I'm hereby directing the enforcement priorities of the United States. We will prosecute every other federal law before we enforce any federal environmental law. And since there are limited resources, we ain't going to have time. And President Lee also goes on television, as President Obama did, and says, any federal official who violates it, there will be consequences and employment consequences. Now that is a matter of just resources. Would that be permissible?
Well, are you asking about how the executive branch how they would prioritize in terms of order of things, or?
Could a subsequent president choose to prioritize the enforcement of every other federal law ahead of environmental laws such that no federal environmental law would ever be enforced again?
No, I think I said earlier, I don't think a president could just say, I'm never going to enforce environmental law, or I'm never going to enforce immigration law. But again, I don't think that's what we have going on
Well,
today.
how about, could a president issue 4-year temporary permits to violate federal environmental law? Print it up. We are deferring enforcement of all of these. We're printing you an environmental polluter pass. You may use this. Now, this is temporary. It's purely deferred. We might one day come back and enforce the law, but for the 4 years of President Lee's administration, you have this authorization to violate the law. Would that be permissible?
I guess the best answer to that I can give you, since I'm non-environmental law expert, is that all agencies marshal their resources and engage in prosecutorial discretion. I don't know this for sure, but I'd be very surprised if the EPA does not, decide and think about, and prioritize which types of environmental violations it's going to make higher priorities or not.
No doubt they do, but there is something qualitatively different issuing an authorization to violate law. For my final set of questions, I'd just like to ask Mr. Rivkin, you talked about the assertion of federal power of this president. And I'm reminded of what President Obama said not too long ago when he was asked if he had the authority to grant amnesty. And his response was, I am not an emperor. Those are not my words. Those are Barack Obama's words. The obvious implication is to grant amnesty in contravention of federal law would be to behave as an emperor. That's in the assessment of President Obama. I'm reminded of the assessment of Professor Jonathan Turley, a known liberal constitutional law professor, a Democrat who voted for Barack Obama, who has testified before Congress that Barack Obama has become the embodiment of the imperial presidency, and he used terms very similar to what you used earlier in this hearing, Mr. Rivkin. He said, Barack Obama has become the president Richard Nixon always wished he could be. I would welcome your thoughts as to the consequences of a president having the sort of unbridled executive power to pick and choose which federal laws to obey, which federal laws to ignore, and which federal laws to unilaterally alter.
Thank you, Mr. Chairman. I wish I had an hour, but let me be brief. I think that It is extremely dangerous situation, as you elucidated in the hypotheticals. It violates separation of powers. My hope is that this is an aberrational, and by the way, I frankly think there's a broader pattern of usurpation of Article 1 prerogatives. This administration withdraws money from the Treasury not in consequence of appropriations in other contexts. This administration acts with disdain whenever you try to exercise appropriations power, whether through an appropriations rider or capping the budget overall. This administration takes umbrage at the House's ability to invite a foreign leader. This administration takes umbrage in the Senate's ability to send a letter to a foreign leader. There's an utter disdain for Article 1. My hope it's aberrational, but if that new baseline emerges, and God forbid it gets sanctified by Article 3, and as you well know from your litigation experience, Article 3 does look frequently in separation of powers in past practice, we are off in a horrible place. No matter how compelling the policy merits of this, it cannot be right, because individual liberty depends most profoundly, not just on the Bill of Rights, but on cabining of powers and exercising of powers only that are appropriate to the particular entity that is doing it. And briefly, it's not just diffusion of power. The reason legislation is for Article 1 is because it benefits from deliberation. It benefits from delays, no matter how people are upset about delays. If you have a sole legislator, is going to be as bad at legislating as frankly, Article 1, we are trying to wage war, because war requires unity of command and speed and dispatch. So it is, in my opinion, you cannot criticize this enough. You cannot be alarmed about this enough, no matter what your political philosophy, no matter what your ideology or party affiliation is.
Thank you very much. Senator Blumenthal, do you have any additional questions?
Yeah,